Thank you, Mr. Speaker. It's a privilege to open the debate on this next important stage of the Terminally Ill Adults End-of-Life Bill. It seems a long time ago since we held the second reading debate back in November on what I think many of us felt was a very proud day for Parliament, where we saw an emotional and passionate but largely respectful debate on what is a hugely important subject which means so much to so many people. Mr. Speaker, I know that there are a range of views on the subject of choice at the end of life. And I know that today is not about revisiting the fundamental principle of assisted dying, but as the sponsor of the bill, if I may, before I address the amendments in my name, I will make some brief introductory comments as to why we are here. And put simply, if we do not vote to change the law, we are essentially saying that the status quo is acceptable. And over recent months, I've heard hundreds of stories from people who have lost loved ones in deeply difficult and traumatic circumstances, which show that that is clearly not the case. Too many have seen their terminally ill loved ones take their own lives out of desperation, or make the traumatic, lonely and costly trip to Switzerland, and then face a police investigation while dealing with their grief and loss. I will give way.
I thank my honourable friend for giving way. She mentioned many real stories influencing this debate. I'd like to mention just one more from my own constituent, Mick Murray, who is in the public gallery today. Mick helped two close friends, Bob and Anne, make the painful journey to Dignitas. Both simply wanted to die at home with dignity, surrounded by loved ones. Instead, they had to make that journey overseas at great cost and legal jeopardy. Mick said, "I helped them out of compassion," and I think that is what is missing from the current law. Does my honourable friend agree with Mick?
Please, we're going to set the example by following the rules of the House. Short interventions, not speeches. There's a lot of other members.
Thank you, Mr. Speaker, and I thank my honourable friend for that intervention. And it was a very powerful point, if slightly long. But it is an important point. There are people who are facing these really traumatic, difficult decisions every day, including Louise Shackleton, who I believe is also with us today.
A point of order.
I thought the debate was to discuss amendments and not a general debate.
It is about that, but I think this is the opening leading to the amendments. But I will make the judgment of that call. Kim Leadbeater.
Thank you, Mr. Speaker. If I may just finish that point, I will give way.
Can I just say to people, if we're going to have continuous intervention, don't be shocked if you end up at the bottom of the list if you continue to make people making the same intervention. I just want to help people, because all you're doing is soaking up time. Jim Shannon will be a good example.
Mr. Speaker, I'll always be at the end, so for me it's very important to ask an intervention. Can I ask the honourable lady, at the second reading she set the scene very well, but since then things have changed. For instance, the Royal School of Psychiatry has said that they have voiced strong concerns opposing the bill. They talk about in regard to judicial oversight, robust protections against coercion, etc., and the effect it will have upon those vulnerable groups, those with dementia, Down syndrome, mental illnesses. Does the honourable lady not respect those viewpoints of my constituents who tell me they're opposed to this bill in principle and all the things coming forward? And this, I feel, doesn't address the issue the honourable lady is referring to.
Kim Leadbeater.
Thank you, Mr. Speaker, and I thank the honourable gentleman for his intervention. He's absolutely right. There are a range of views on this issue, and I'm deeply respectful of that, and I take all those points into consideration as we embark upon this debate again today. And perhaps, Mr. Speaker, most importantly, I've spoken to terminally ill people themselves over recent months. And I think it's impossible to know what it must feel like to receive a terminal diagnosis. And I have nothing but admiration for people who have bravely spoken about their personal situations, some publicly, including, of course, Dame Esther Ranson, and others who have done so privately, many by emailing their MP. And I know mine is not the only inbox full of those emails. I also want to thank colleagues here in Parliament, of course.
Thank you for giving way. Will my honourable friend distance herself from the correspondence from Dame Esther Ranson, who accused those of us who have concerns about the bill as having undeclared religious beliefs? Many colleagues found this distasteful and disrespectful.
I thank you for that intervention. I haven't seen those comments, but it's absolutely right that whatever our views are on this issue, we must remain respectful. And I also want to thank colleagues here in Parliament, MPs and indeed staff, who've shared their personal stories of loss with me over recent months. These are, and this is a really important point, these are real people with real stories, and they must always be at the heart of the debate. Mr Speaker, public support for assisted dying in this country has been consistently high for a long time now, and we've seen movement in jurisdictions around the world, including, of course, just this week in Scotland. And I want to congratulate colleagues in Holyrood, and particularly Liam MacArthur MSP, for such a compassionate and respectful debate, which I hope we can emulate here today. It is right that we consider this change with great care, as we are doing today. But we should also remember, as with other big social changes, like giving women bodily autonomy regarding their reproductive rights, or allowing gay...
Order. Thank you. We did say, as we've had this conversation, a very early introduction. I think that's why members will begin to get frustrated. We should be now speaking to the amendments. Kim Leadbeater.
Thank you, Mr Speaker. I will move on to those amendments. If I can just acknowledge the work of the Bill Committee in relation to those amendments, because there was a huge amount of work done by members across the House with a range of views.
Look, I'm really bothered because it's the day for the amendments, and we really need to understand the views of the amendments. And as the member in charge of the bill, I'm sure that you really want to get into the depth of the amendments and not continue in the role. Kim Leadbeater.
I do indeed, Mr Speaker, you're absolutely right. But the amendments that we're discussing today do build on some of the work of the committee, and as such, I think that is important. We took a lot of steps to strengthen the bill during the Bill Committee, and I was pleased to work collaboratively with colleagues in that way. Mr Speaker, and again as I come on to those amendments, which have been tabled in my name, the Government is of course neutral on the issue of assisted dying, but has always been clear that workability is essential if the bill is to pass. So I've worked closely with an outstanding team of civil servants from the Department of Health and Social Care and the Ministry of Justice, and it is with their technical advice regarding amendments tabled today to make the bill workable and to give coherence to the statute book that I am tabling these amendments in my name. Of course.
Friend for giving way. Would she confirm that those civil servants are 100% comfortable with the impact of this bill with people of disability, mental health issues, neurodiversity and other medical conditions, and the fact that they will not be coerced or under pressure because of this bill?
I thank you for that intervention. I mean, the civil servants are clearly neutral on the issue, so they certainly haven't expressed any opinions with regard to the content of the bill. What they have done is merely provide the technical advice and expertise, and have done so brilliantly in that regard. So I come on to new clause 10, amendment 52 and new schedule 1 tabled in my name. Mr Speaker, as well as correcting the injustices in the legal situation, one of the key tenets of this bill is choice. Choice for dying people. But it's also very important that there is choice for doctors, other healthcare professionals, and indeed anyone else. The bill was always clear that no registered medical practitioner or other health professional is under any duty to participate in the provision of assistance in accordance with the Act. But this new clause expands that protection. It broadens the people to whom it applies and the functions to which it relates. It also introduces new Schedule 1, which makes provision for enforcement of this right not to be subject to any detriment in connection with the bill. Mr Speaker, of course I will.
I'm very grateful to her for giving way. Does she accept that there may be a weakness in new Schedule 1 in as far as it protects a person from actions taken by their employer? It may not necessarily protect, say, an agency worker who is contracted to perform a service, but then the original medical body decides not to then re-engage that person's services.
I thank you for that intervention. I would refer him to my previous comments that the bill and these clauses and these schedules have been drafted with the highest level of legal expertise, so this isn't something I anticipate as being a problem. Of course.
The bill does allow applicants to shop around for doctors. Yes. And it strikes me that there is a danger that some doctors will specialise in the provision of that service who might have an ideological view of this bill, giving it rather greater scope than she intends.
I reject the assertion that patients will shop around. Bearing in mind we're talking about dying people. They're not in a position to start shopping around for services. But I also agree that the bill is particularly strict in that regard. There are very strict protocols to be followed that doctors have to follow.